Well, hi there guys, Alex Woods here vlogging at you about a really important topic, and I think something that is a little bit of a, a little bit of a surprise for a lot of litigants in person when they first sort of commence the proceedings, and they're quite astonished to discover that their opponent has made a strikeout application. So I'm just going to cover the issues in such cases and where you might have gone wrong with your claim, and then how you can remedy the problem and some sort of steps for the way to go forward. Now, the thing about strikeout applications is that amongst lawyers, and if you look at a legal tome, if you look at the practical law service, for example, that they talk about the fact that strikeout applications are very rare, that they should be used sparingly. And you might be forgiven for getting the impression that there's nothing to worry about. A strikeout application is unlikely to be brought by your opponent, in a small claim. After all, a small claim is meant to be a low value, sort of more friendly, where the rules are more relaxed. You may be thinking, goodness gracious, I've just brought a claim for £1,500 and I'm confronted with an opponent who's brought out a strikeout application against me, and I've had to go to court for a separate hearing. Now, the very important thing, the first thing to understand about strikeout applications is that they are often made prior to the allocation of your claim. So you think it's a small claim, £1,500. This video actually came about as a result of an inquiry I had and a telephone conversation I had with a potential client who had brought a claim against a hospital for basically poor care by the doctors, by the service, delays, failure to supply the correct diagnosis, and so on and so forth. And they'd had to go elsewhere privately and spend some money on some private care, etc., etc. So it was a sort of a clinical negligence claim, although hardly could be graced with such a word. And it was only a relatively low value of about £1,500. So they, were quite surprised when they found themselves on the wrong end of a strikeout application. Before, as I say, the claim had been allocated, it looked like a small claim. And here's the other thing about this sort of situation, where you are bringing a claim against a large corporation, company, or in this case the National Health Service, you need to be careful, because a bank is another classic example in financial and selling cases, because they will have a battery of lawyers, and it'll be absolutely like having a cup of tea, bringing a strikeout application against you to try and get rid of your claim, and they may want to do that for policy reasons, to dissuade other people from bringing claims against their organisation, be it a bank or the National Health Service. Now, I've got two cases that I'm going to use to flesh out some detail on this topic. But to come to the first point about allocation, if your claim, and since a strikeout application can be made at any time during the proceedings, but it is often made quite early on, where the claim has been improperly prepared, is inadequate, insufficient for a variety of reasons I'll come on to. And you may have issued your claim, £1,500, let's say, and you are, now you're wondering, well, what's, it's going to be relatively straightforward, and you're surprised to get a court order and perhaps correspondence from the other side with draft of their application, copy of their application rather, and you've got to turn up at court in a few weeks' time for an hour hearing for a strikeout application. Now, the thing is, it's not been allocated to the small claims track yet, so you face the prospect of having to pay the other side's legal costs if you lose that application, all right? Now, they could send a barrister to court, they'd have a solicitor preparing for that hearing, so it could be hundreds, it could be thousands. I mean, even for £1,500 claim, it could be 500, it could be even £1,000 they might be asking the court. Perhaps unlikely to be that much, but in a low value claim. But the point is that if you lose that application, or if, let's say, the judge says that the application, although they're not going to strike out your claim, this is more common, there are some inadequacies in your claim, and they need to be remedied, and you've got to make an application to amend the claim, or you've got to file and serve amended particulars of claim because your original claim was poorly brought, in those circumstances you are at grave risk of the judge then, after that hearing has been heard, making an application of costs against you. And then you've got to make an application to amend your claim, and that costs, I think it could be £255 if memory serves me right. Have a look at EX50, which is the rules on costs in the County Court of England and Wales. So that is, now you can imagine an opponent with deep pockets is not going to hesitate to use a strikeout application to intimidate an opponent, okay? Because you're probably thinking about throwing the towel in if you're faced with a strikeout application that's likely to incur some costs. So now, just to give you some classic examples of where a strikeout application may be made, it could be that you've incorrectly particularised the claim, so you've not actually laid out the story which gives rise to a cause of action, like negligence in that case. You've not actually said, well, the doctor told me X, I then subsequently learnt for a private practitioner that I should have been dealt with, that the problem was in fact Y. And because of the 3 months delay between meeting the NHS doctor and the private doctor, the condition worsened and I was forced to take time off of work to look after my partner. He had to get extra private had to get extra care privately, or had to be taken into private hospital. We had to pay for medication, and I had to pay for travelling expenses because that private care home was a fair distance from me, or blah 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 blah. So you're kind of particularising the claim, and notice how you're also particularising the losses. So you're pointing to the error, the negligence, and then you are particularising and quantifying the losses. Now, another area in which you can fall foul of a strikeout application is where you haven't particularised the losses. It's just a vague, oh, I suffered injury and I'm claiming damages of £1,500, but you haven't actually specified what those damages are. In a personal injury claim, they may be for loss of amenity, for suffering, for the actual injury, compensation for the actual injury itself. But you might actually be claiming more for the costs of, of reparation, or what's called special damages, rather than the damages that relate to that particular injury in a personal injury claim. So another category of strikeout may be where for instance, let's take a financial mis-selling claim under the unfair relationships test. You've got to meet certain criteria in order to come under that particular bit of legislation to sue a bank for mis-selling a payment protection insurance product. A very good head of claim where you're demonstrating that there's an unfair relationship and you're being mis-sold an insurance product by a bank, yeah. But there are exceptions. For example, you can't do it if you are a limited company. And I had a case like that the lady had brought her own claim, and unfortunately she was a one-man band, but she'd made her husband a director. She said she wasn't actually a sole trader. They'd incorporated a limited company, of which they were both directors, and therefore they couldn't avail themselves of the unfair relationships test. So you could face a strikeout application on that basis. Again, you'd then have to amend your claim in order to deal with that initial error. Other areas are, just having a look down the list here, you could have brought a claim against the wrong party, or a second defendant who's actually got no sort of legal relationship with you, so really shouldn't be on the claim form, the particulars of claim. It may be limitations, it may be you're aware of time. But the point is, ultimately, your opponent has found some holes and weaknesses. It may just be a weak claim, but your opponent has found a sort of holes in your claim, either the way it's been prepared, or either in the substance of the claim itself, or some legal issue that you're missing. You don't have to sort of necessarily lay out the specifics of breach of contract or negligence, but you at least have to identify, I bought a television from John Smith, got it back to my home and it didn't work. You know, I went back and asked for my money back, he wouldn't give it back to me. That's a clear contract. You don't need to kind of spell out like a law student, the various components of a contract and where a contract is breached. But you do, as I've indicated, need to spell out in clear steps the facts that give rise to that claim in contract or negligence or whatever it might be. So there you go. This strikeout danger is nearly always where a consumer is bringing a claim against a large corporation, and it's used to intimidate you, and they don't care if it's not successful. The very fear and the prospect of having to pay legal fees to the other side and having to make another application to completely amend your claim would give most consumers a sleepless night or two and food for thought whether they really want to carry the claim all the way to trial when they're already on the back foot. Okay. Now, the real advice here is, you won't be surprised to hear, you've got to find yourself a lawyer. If you've brought a claim and it's been poorly prepared, poorly particularised, poorly quantified, there's an error in the law, or something of this nature, and you've got this application because the other side will have sent you their application for strikeout, and the court will also have sent you, or probably have sent you a copy as well. Then, if you're faced with this, you probably need to phone a lawyer, I'm afraid. Now the problem is, and I'm going to plug our service here because I think this is, the perfect hole which our service plugs, if you like, which is, this is what I'm trying to do with the small claims support service, is provide you with sort of a light review assessment phone call to help you through that particularly tricky period, because you're going to need a little bit of specialist legal advice in my view, but you don't want to end up instructing a lawyer formally to conduct the proceedings. You really just need a decent lawyer at the end of the phone, or to review a document you've prepared. Okay, so now you may not decide to avail yourself of a lawyer, and indeed your opponent probably knows that not only have you got the risk of the cost of strikeout application, not only have you got the dangers of having to make an application to amend your claim and the court fee there that you may never get back, you've also got to spend money on legal advice, and lawyers are expensive. You can see how powerful a strikeout application can be. So what are the lessons to learn from this? The number one lesson, of course, is take great care when you're preparing your claim and your particulars. That is really the most important thing. And incidentally, also make sure that you've properly attempted to resolve the matter without recourse to legal proceedings. Comply with the pre-action protocol, and make sure which in brief means you've spelt out your beef with your opponent and you've attempted to settle it with your opponent without going to court. You've sent them a nice long letter explaining what it is they've done wrong and what they need to do right, what they need to do to put it right. Now, if you're watching this video, you probably are already in the mud. So you'll wonder, well, okay, fine, but I'm sorry, I'm a consumer, and in many ways the civil procedure rules are pretty unfair. If you think about it, you're sold this small claims track service, and then, hang on, little $1.5 grand claim. I'm told that it's a case that keeps lawyers out, and there's no danger of me having to pay an expensive opponent's legal bill, and yet you discover this comes out like a rocket out of the blue. That your opponent makes a strikeout application, and you're like, well, I thought it was a small claim. Well, as I said earlier, it's not a small claim until it's been allocated to the small claims track, and that won't happen until after you've filed your pleadings, your particulars of claim, defence, reply, counterclaim. Only after that stage, when you complete the directions questionnaire, is it now allocated to the small claims track. Anyway, you're in the mud. What you need to do is act quickly to get your claim right, to amend your claim. Okay, it's simple, common sense. You've cocked up on the initial claim. Now sit down, get some legal advice. If you think you can do it yourself, that's fine. Watch a vlog. There's a lot of information online to help you. And amend your claim. Okay, and obviously look at the strikeout application and see what it says, and try and address the criticisms in the application and create a fresh claim. Okay, then try and get it agreed with the other side. So okay, you're basically saying to the other side, okay, fess up, got it wrong, my claim form and my particulars of claim need to be amended. I've done a draft of how they should look now. Will you agree them? And send a revised particulars of claim to your opponent and say, are you happy now? Okay? And do this quickly before you get anywhere near the court hearing date for the strikeout application. Now, if they're instructed, as they almost certainly are by lawyers, the lawyers will go, I guess we better. It then actually puts the ball on their side of the court, because if they proceed with the strikeout application, which costs court time and it costs legal fees, when actually you've prepared a completely satisfactory amended set of particulars of claim, you can then agree with them to vacate the hearing and just have a paper exercise in which you send a consent order, it's called. You get them to sign, you sign, and you agree these amended particulars of claim. Okay, you might need a little bit of legal help with drafting of a consent order. You could, if it was a smallish, low-value, uncomplicated claim, perhaps just do it in a joint letter and say, here are the amended particulars of claim. I'm litigant in person. I've got my opponent to sign. They're happy with these amendments of claim, and they withdraw their strikeout application, and then we can then continue with the proceedings. So that is the ideal, is to do proper remedial work, accept you've made an error, remedy the error by producing the correct particulars of claim that you should have brought from day one, get the other side to agree it, send it to the other side and say, will you agree these? Get their signature, send it all to court, and ask the court now, by consent of both parties, to accept your amended particulars of claim and basically get rid of the old one. I haven't got time to go into the detail of whether that's going to cost you, but I have on a couple of occasions got away without then having to pay a £255 application fee and fill in a complicated application form and all of that. So that's the solution. So I hope that all makes sense. And as I say, on a few occasions I've given advice in this area, and we do a small claims track rate if you want to use us for any of the aforementioned of £150 plus VAT an hour. Fine. If you're organised and you email a lawyer nice paragraphs explaining the story and the problem, you attach all the relevant documentation, including in this instance the strikeout application, the court order, your claim, if there's a defence, any defence. Strikeout applications can be made before they've submitted a defence, but there might be a defence. Email it as a PDF, and I can quickly, or any lawyer can do this quickly, but we've got a bespoke sort of discounted service for this. Read the documents, read the email, give you a telephone call and tell you where you've gone wrong. So we kind of offer a special sort of limited advice service as lawyers to people who don't want to instruct us formally, like your opponent has instructed lawyers formally to conduct the litigation. We're not conducting the litigation for you, we're just giving you help and assistance. And as I say, I reckon probably, if it's a small, relatively non-complex claim, 2 to 3 hours of our work, what's that, £450 plus VAT to get your papers in apple pie order. Just be clear, we wouldn't actually draft the amended particulars of claim for you for that fee. We would get you to draft them, and then we would give you notes and review them. Good, well I hope that assists. I am going to be doing a video on the sort of the intricacies of the small claim process, particularly as you know, falling foul of it for certain exceptional categories like personal injury or housing disrepair claims. Don't forget that a small claim isn't always a small claim. Just because it's under 10,000 doesn't automatically mean it will be allocated to the small claims track. Okay, I hope that's been of help and look forward to vlogging you in the very near future. Bye for now, folks.